Every time I come in thinking we're going to have kind of like a short class, it like totally does not work out. Look out, we only have like an hour of stuff today. It's going to be really fast. Doesn't work. So we are now done with the introduction. And we will now move into our intellectual property discussion. And Bob and I are both going to do that. Again, I think this will be a lot lighter than the one from last semester and hopefully more practically applicable. And then whatever time, I'm going to go upstairs after, or whatever time we have after, we can go upstairs. So, let's talk about intellectual property. I am not a lawyer. Bob's had many careers. I do not believe he is a lawyer either. So on the one hand, you really can't, we have no credibility. And you should caveat everything we say and go ask a lawyer. But on the other hand, most of the times when a lawyer gets up, I find they just give too much initial information and get too detailed. And so what I'm going to try to give you is my Cliff Notes version of what's been useful to me as an entrepreneur about these different things and how I think about them from a practical perspective. If you would like the lawyer version, I would encourage you to go watch the video from last semester. And we'd be happy to get you more help. We have other IP professionals. Did we ever get you any, Dwayne? Did you get to talk to any IP people? Were you asking about it? Is it you or is it
well,
else?
Nick Newcoff from
But he's not really IP.
No, but he was at least enjoying himself. But no, we haven't.
Was there somebody else that was asking me for IP?
I was also for trademark, but it's kind of the same thing.
It's kind of the same thing.
We're looking for someone to help us with IP.
Okay, well I definitely have at least 2 IP people. I definitely have a trademark person. So email about those for specific intros and I can get you more specific stuff. This is going to be more high level.
Let me try it. First, high concept.
Yes.
I frequently say that this course is intended to teach you how to use the machinery of free enterprise. Intellectual property is machinery. That is a number of mechanisms in law and business have been constructed under that rubric. And so we're learning how to use, what we're trying to share with you is how to use this machinery to advance your companies.
Yes. We're thinking about them as tools, not necessarily as just purely legal concepts. And that's certainly going to be my perspective to describe. Here's how I would use this, when I would use this, why it might not be worth it at certain times. So, we're going to talk through a bunch of different things. Patents, trademarks, copyrights, other intellectual property concepts. So the first one that's probably what most people think of when you say intellectual property is a patent. So here are some examples of patents. There is a patent on the windshield wiper. Sometimes in hindsight they don't look like things you would patent, but there was somebody came up with the first, driving down the road, it's raining, they can't see through the windshield, it was a big problem. Somebody came up with an idea for like intermittent windshield wipers, I think was the key part. Like that they don't just keep going, that they like go and then stop and wait, and then go and stop and wait. And that was like way better than either just on all the time or off. And in fact, there's a guy here in Austin, Chad Bacchius, who was the founder, one of the founders of and CEO of Socialware, which is a very successful startup here in town. And I believe it's his grandfather has the patent on the intermittent windshield wiper. He was in Trilogy equipment. There's often patents on pharmaceutical drugs. You have to take a lot of investment in research to find and create a drug. They patent that. Then after a while, you hear about these generic drugs, right? Like generic versions of them. I recently met a company doing special magnetic fields, Stephen Strauss's company, and they've got a special way of developing certain kinds of magnets that have special properties, and they've patented all kinds of things around that. And that their whole business is going to be just not actually producing these magnets, but licensing out the technology to other people that can go do that. So patenting is very important for them. There is, in my business, in email, there was a challenge response system that was patented. This is the idea of, I send you an email, and then it says like, hey, I haven't seen an email from you before. In order to prove that you're a real person, click on this link or respond to this, and then your email will go through. And that was patented as a way of helping to reduce spam. Many computer algorithms will be patented. That's probably one of the most likely things if you're building a website or a Facebook app would be the algorithm or something behind what it does that might be your secret sauce. And then there's also something called the design patent, which is not so much on how it works, but actually how it looks and what it is. And so you might have, I believe there's a design patent on the iPad. So if somebody makes something that looks exactly like an iPad, even if they didn't violate the functions of how the screen works or things like that, it still violates their patent. You can do that to your user interface on your website. you might say initially it was defensive, because you owned it, and nobody else could keep you from doing it. But then
We
in
wanted
order to
internet
make
to be a
it,
standard, so, and people wouldn't use as a standard something which somebody else owned.
yeah, kind of like Flash. Just as an example, right? So like, what is one of the big aversions people have in Flash, or even Apple and other people besides it being slow, is just that it's totally controlled by one entity. When Sun wanted to make Java popular, what did they do? They gave up control of it, right? And they basically had to say, we're going to let it become its own thing.
The largest monopoly in the history of the world, the American Telephone and Telegraph Company, previously, was founded on a patent by a guy named Alexander Graham Bell, who beat by one day another inventor who had a patent on the telephone. Elisha Gray was his name. It's a famous story. That patent was used to build this huge monopoly.
So those are some examples of what patents are. So let's talk a little bit just practically about, as a startup, how you would think about patents. So again, there's lots of different, patents can be a complicated thing. Big companies do lots of patent stuff, but as a startup, this is what I think it usually comes down to. It costs about $10,000. You can probably do a cheap, crappy patent for $5,000. You can easily spend $25,000 or $100,000 if something were extremely complicated and detailed and needed to be documented in lots of different ways. So, but most startups I talk to, when they go get a quote for like, I'm thinking about getting a patent, they go talk to a patent lawyer, it comes back and it's going to be about $10,000. And it's going to take 2 to 4 years to issue. So you have to write the patent and submit it, and then actually, get accepted, assuming it's going to get accepted. I don't know what the acceptance rates are. I don't know how many get accepted versus not. But it takes years. It's not like, it's not 1 year. There's some talk about like fast tracks. You can pay extra to make it happen faster. It's still going to take a long time. But maybe you can make it happen a little bit faster.
So the examiner is checking, the reason it takes so long is the examiner has to check for 3 things. Your patent has to be useful, it has to be novel, new, and it has to be not obvious. And so they pour through what's called the prior art to see if it's useful, those 3 criteria. And that's what takes the 2 to 4 years.
Investors like them. They're not required. Somebody came up to me the other day and was like, do I have to get a patent? Is that required? Well, it's not required. In fact, most startups don't have it. But given 2 startups that were exactly the same, the one that has one is better than the one that doesn't. Right? Like, it's a good thing to have some defense for defense and other
Are
things.
you going to touch on the 2 purposes of the patent?
Yes.
There it is.
So can be used defensively or can be used offensively. And you notice I put next to both of them, that costs money, meaning just having the patent doesn't actually get you that much. And having the patent, using the patent is actually very expensive. So there's, beyond the $10,000, one thing that often small startups look at is they might say, even if we had the patent, we couldn't use it. We couldn't take some big company to court because that's going to cost $1 million is about what it usually costs. This is not from experience, this is from other people, lawyers and Italians.
Way underestimated.
A minimum of $1 million to go fight a patent lawsuit. So if you want to sue somebody, it's like, all right, just to find out if I'm going to win, I better be ready to put up $1 million or more.
So sometimes as a venture capitalist, rare, but sometimes you'll see in the use of proceeds, we want to raise $38 million, and you'll see a line item, $6 million for patent litigation. And investors do not like that.
Yeah. So in general, it's good that you have it. It's important to realize what it really is and what it's really useful. And I'd say generally, investors are going to see it because they like it defensively. That means at least it makes it really hard, much harder for someone else to tell you you can't do anything. Or if they do, you can be like, well, I've got, and then you can flash the patent at them and say, what about this? Even if sometimes somebody might accuse you of doing something else, if you have a patent, you can say like, oh yeah, well, but you're violating my patent. So since I'm violating your patent, you're violating my patent, why don't we all just be friends? And you're just like, and this is very common. You're just like, okay, well, we'll give you a sign off that you can violate our patent, but you have to give us a sign off that we're going to violate yours. And now we're all happy. And so you're able to barter it to keep you from being in trouble and to reduce costs. Offensively, if you have a patent and somebody else starts to do your thing, you have to go sue them. Like I said, that costs a really lot of money. And so so often that just won't be an option.
Is that what Yahoo's doing right now?
That's on my next slide. And acquirers like them. if someone's going to buy you, they like the fact that you have a patent. Again, it's not something that's going to be required. It's not they wouldn't buy you if you didn't, but it's better if you do. But for all the same reasons.
Right, so the reason investors like patents is because acquirers
Yes.
like patents.
Yeah.
And the reason that that works is acquirers often have the resources to enforce the patents. So even though the startup doesn't, the acquirer might be IBM.
Yeah.
And they can, so they'll buy the patent because they can, the company with the patent, because they have the resources to enforce them.
Yeah, and it's a great point. The real reason investors like them is because acquirers like them. And so they just, that makes it like, oh, you're going to be more attractive to be acquired and more defendant. A lot of times with business, especially with software and websites and Facebook apps, people say like, well, what's your competitive advantage? And a lot of times if you are a first-time entrepreneur creating a website business, you do not have any competitive advantages and you will not have anything to patent. And that is just the way it is. And that's okay. So the bad thing is to pretend that you do when you don't. To try to like pretend I have some competitive advantage or pretend I'm going to patent something stupid that's not going to really work. So
And this varies by field. So for example, in drug discovery, patents are very, 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 very important.
yeah.
In software companies, they're much less so because some of the other alternatives of IP are used instead of patents. As you see.
And then, particularly in software, this is going to be more software than everything else. The time cycle thing is very important too. Like with a lot of things that I'm working on, the way I think about the patents is often that the whole life cycle of the technology I'm developing is sometimes 3 to 5 years. Meaning, 5 years from now, the whole thing I'm doing will be irrelevant. So, what's the point in getting a patent 4 years from now? It's like by the time the patent gets issued, we probably won't even be using this technology anymore anyway. So it just kind of becomes an exercise in futility.
Two terms of art. So when you use a patent defensively, that's called you get freedom to operate. That is, having a patent gives you freedom to operate. No one else can block you. And that's the other term. Using it offensively, you block your competition from competing with you by asserting your patent against them. That's called blocking rights. So you'll often hear either freedom to operate or blocking. Those are the two uses.
So, who in the class has applied for a patent? Bob has. Anybody else? I'm sorry, what's your name? I'm sorry, what's your name? Cynthia? Hi, well, thanks for coming today. What, your patent was the Ethernet patent. Did you write it, or did a lawyer?
All the way. So I was working for a large company called Xerox. So they had a system for this. So I wrote what's called a patent disclosure. And UT has a similar thing. So you write down to the engineer, you think it's novel, useful, and not obvious. And you send it to the legal department. And the legal department decides that it sounds right. And then a lawyer comes and interviews you and writes the patent. Because the patent is written in legalese. So you really can't write your own patents. I thought you could, but you can't. You need a lawyer.
And that's part of why they take so long, is because you, and often it's a technical thing, have to then try to describe to a lawyer how to rewrite your thing, which is just painstaking.
In my case, which was in the 70s, there were no software patents allowed, period. No software patents were allowed. Ethernet was largely implemented in software. So I had to explain to this lawyer how I would have implemented Ethernet in hardware so that he could write down a completely ridiculous method of implementing it, but it was patentable because it was hardware and not software.
So is it like, because patents range from like genomes to biotech companies manipulation to software. Is that office capable of like, how effective is the patent office if you're covering every type of innovation that's possible?
Yeah, I think you'll probably get a lot of different opinions on that question, but I'm sure you hear some people like, oh, it's terrible, it sucks, and other people say they probably do a good job. I'm sure they have specialization, right? When you send in your biotech patent, it doesn't go to the software guy, right? It goes to the guy that reviews all the biotech patents, right? Now, I think regardless, it's a really hard job, but I do think they're trying to be designed.
There are thousands of patent examiners, and they have a
a great question. So, U.S. versus international, or, there's different patent laws. There are ways to get a patent that's done internationally. That's going to depend a lot on the scope of what you're trying to do and where you think it's going to be relevant. With many software things, international can be very relevant because things can be copied easily internationally. With something else, it might not matter at all. Another thing to keep in mind, though, is the enforceability part. Just because you have an international patent, guess what? It's even more expensive to go sue somebody in another country and try to get them to not do your thing, right? So,
The conversation you'll often have with your lawyer is how many countries can you afford to have a patent in? And then you say, well, that country isn't important. China.
For me, like, I'm now part of Return Path. They bought other inbox. And of course, one of the first things after the acquisition that their lawyer writes to me and says is, hey, let's document any intellectual property you have. Are there any patents we should write? Because they're a big company, they have the resources to go do these kinds of things, right? But then I was like, oh man, the last thing I want to do is go sit down and write a patent disclosure document like with a bunch of lawyers because I'm going to spend a week on this thing. It's going to be a lot of time. And so I got down to really think it's really worth it. Is this thing really patentable? Like, is this really novel? Because it's a big time commitment for me, even though they're trying to make it so I don't have to do any of the work. Right? And it's just still going to be a huge time commitment of writing the initial one and have to go and review what they did and try to understand legalese to be able to tell them what's right or wrong. And, it's just not fun. I don't know, not fun to me.
And how long do they last?
20 years.
Is it 20 right now?
Used to be 17. They upped it to 20.
So, to be honest, as I was putting this together, a great resource for this stuff is just Wikipedia. And, so I was putting this together and I wanted to look up some of the details of what technically was covered by trademark or other things. And Wikipedia is a great start for getting some real basics on this. Yeah.
Is there a place you can go to see the patents that have already been patented? Just kind of search.
Yeah, in particular, Google has a patent search that I haven't used much, but it's, it was a big deal when it came out because it used to be very hard to do that, and they indexed it all and made it really easy to search, and so I believe that's where most people would do that now, as a specific search engine within Google that's just patents. Anyone know anything better?
USPTO office, their website, the USPTO, US Patent Office.
Okay.
That's good because it has trademarks as well too, so if you want to do trademark search. But a lot of those self-help trademark things will do trademark search as well.
Okay, so someone mentioned Yahoo. So who's in the news for suing another company in a patent lawsuit? So, this is big in the news right now. Yahoo is suing Facebook, and I am not an expert at this suit. I have not reviewed it in detail. I can only tell you what I've learned on Twitter. 140 characters at a time. But what I'd summarize it is, what they're being accused of is that the story, the drama behind this is Facebook's getting ready to do an IPO, which means they're in a quiet period, which means they cannot speak about a bunch of these things. So strategically, that was a very kind of nasty, kind of jab time for Yahoo to sue them, because Yahoo could put this stuff in the press, and Facebook kind of can't say anything to defend themselves. And the theory would be that Facebook would be more amenable to settling, to maybe just trying to make this go away so that it's not hanging over their head when they IPO, and that it doesn't introduce doubt into the IPO and effectively lower their IPO price. Now, I actually don't think anybody's going to care that Yahoo's suing Facebook over this patent stuff. I don't think that's going to affect the Facebook price myself. I don't think it's I'm not going to buy Facebook because, man, they're screwed. Yahoo's going after them. I don't think that's what's actually going to happen, but that's the theory of what will be going on here. And in particular, Yahoo is a very large company. They've developed a lot of their own patents, and also through acquisitions of many other companies, they've developed a huge patent portfolio, as does Apple, as does Facebook. Well, Facebook, it turns out, is proportionally less than many other companies, probably because of partly their culture. And so, there's it's one of those things, they have a million patents. There's a million things they could claim that they're infringing on, many of which maybe they are, maybe the patent's valid, maybe the patent's not, maybe it's never even been tested yet in court. And so that's kind of the general positioning of it. And so it doesn't look like that's working, although who knows what's really happening behind the scenes.
You just touched on a key point, another key point, which is, so say you have a patent that's just wonderful, and you see some other company that's violating it, so you sue them. Well, they immediately sue you back.
Yeah.
So you're suing them for infringement, and they're suing you for invalid patent. So they say, not only are we not infringing your patent is invalid, and we're suing you. So suddenly you've got your lawyers who you pay $500 an hour to are busily defending you against the countersuit, so it gets very expensive.
Yeah, I need to make a chart. I would make a nice little flow chart here of the process of getting a patent, and it's like apply for patent, wait, patent gets approved, wait, sue somebody, and then you get the answer. And so the first time you sue somebody or they sue you and it actually goes to court, that's when you really get to find out if the patent's any good. Because it being approved that's not the proof of the pudding. The proof of the pudding is when you use it to sue, it really gets looked at close when you sue somebody. They try to look at it close when they approve it, but they really look at it close when you sue somebody. And then they decide for real. And then once you've won in a lawsuit, that doesn't mean it's over and you win everything after that. But that's a really significant milestone. At that point, you have now case behind you and other stuff, and that's the thing where you start to feel comfortable about it and go like, okay, we're winning lawsuits with this. Now we can depend on this patent. Okay, yeah.
Did you hear the update about that?
No.
Facebook bought something like 750 patents from IBM.
So it's like they're beefing up their war chest. It's totally it. And now oh yeah, well, guess what? We got these patents now. You're infringing on us. So, what are you gonna do, right?
Is that what they did?
What?
They bring in a ringer?
Yeah, that's the way this game goes. And this is a game big companies play. That's part of the point you should get out of this, right?
Well, IBM gets billions of dollars a year in patent licensing fees. Kodak gets billions per year. Well,
they still went bankrupt.
not only did he spend the money well.
Yeah.
What about Xerox?
Xerox boomed during the 50s, 60s, 70s, into the 80s on its patents, which protected it against competition in the copier business. But then those patents all expired because they only last 20 years. And the Japanese came in, and Xerox is about the same size as it was when I went to work there in 1972.
I was kind of referring to the tech development, where they developed all the mouse technology and all the other stuff. First viewing.
They didn't patent it.
They didn't patent.
They gave it down, right?
Basically.
Well, there are some patents. Well, there was a certain ironic moment in which Steve Jobs sued Microsoft for stealing Xerox's technology.
Yeah.
That didn't go anywhere.
All right. So last question on this. So what should you guys patent? Let's turn this back on your companies. So your companies you're going through right now. Who has something they should patent or is thinking about patenting? Let's talk about it. Are any of you considering patenting anything? Have you?
Something useful, something novel, something not obvious.
So doesn't talking about it make it prior art? Or-
Yeah, so it's a great point that we haven't, an important point we haven't talked about. So at what point do you disclose it? What makes it out in the public domain? At what point does that clock start ticking?
That was a great catch.
Yeah, totally, we whiffed that one. So thanks for bringing that up. So this is the one place where the U.S. actually differs from international law. It is not, so I generally just focus on the lowest common denominator, which is international. But the basic rule is you have a year from the day you disclose it to patent it in the U.S. And disclosing it means you tell it to someone publicly that has not signed an NDA, or it's not marked confidential, they're not an employee. And so that would be a reason to get people to sign NDAs. If you're talking to investors, you might say, we have something to patent, and you might go tell them generally what it is. And if they say, well, show me the specs, I want to know the details. That might be the one case where you can say to an investor, you know what? Unfortunately, we're filing a patent for this, so I cannot disclose this to you publicly unless you sign an NDA. We can restrict the NDA very, 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 to only cover this one thing I'm going to tell you, but unfortunately, I can't tell you it unless you sign an NDA because that would cause us to trigger our disclosure. And
Well, internationally, you don't get the year.
internationally, you don't. Yeah. So So they still might not sign the NDA, but at least they would not be stupid for asking them to sign the NDA in that situation. Now internationally, you don't get the year. So as soon as you disclose it, you can no longer patent. So in general, what you want to do is not, if you think something is patentable, do not disclose it and document it and get that filed all at once.
So blurting it out, as Josh just invited you to do, in this setting, would constitute a public disclosure.
I actually would disagree with that. At least that's not what I was encouraging you to do. So the difference is, I would say, what do you have to patent? And you might say, we have an algorithm for how we clean data. And that was just saying we have an algorithm for how we clean data is not disclosing it or giving it out.
How does it work?
And then we say, how does it work? That would be the part, right? And this gets back to the whole thing about talking about your company, right? When people say, you know, like, hey, I can't tell you what we're doing, we're in stealth, right? It's like, well, okay, are you a car company or are you like making like, you know, razor blades? Like, you know, give me something, right? Like, there's a lot you can talk about without disclosing your secret sauce. Don't disclose the secret sauce, but you can talk about what it is. And that was more of the question I was intending to ask, which is just what types of things are you doing that you might have.
So sticking with our theme of energy efficiency, we're looking at a way to make Hadoop clusters more energy efficient, which nobody else has done so far, at least not that I know of.
Yeah. And so you might patent this method of making Hadoop clusters more efficient, this algorithm and this process.
What kind of Hadoop clusters?
Yeah.
Oh.
Anybody else?
What's a Hadoop?
No, it's all about disclosure. So what they're saying is, in the US, you can announce something publicly and still file a patent out as long as it's within a year after.
Okay.
Internationally, as soon as you let the cat out of the bag, you lose your ability to patent it.
Okay.
So you have to file the patent before you file the patent, not get it approved, but just submit it before anything's approved. Now another trick people play, and this gets into the stuff you should ask lawyers about, is you can submit the patent, and that sets a date, and you can then modify it. Like you can submit updates to it. And I don't know I don't want to mess up the details of how that works, but effectively, my understanding is you can benefit from your earlier date and potentially submit new information.
So there are attorneys, unscrupulous attorneys, although that's redundant, who they game the patenting system. So they'll establish an early filing date, and then they'll watch what happens in the marketplace. And when they see something interesting, they'll file a modification to their old patent that incorporates what's already in the market and claim that they filed it back then. It's very ugly business. It's the negative part of patents.
At the crawl, that was probably amongst the team, our biggest question was, how does it work? And every little bit of detail you gave me was ask more. Finally, I developed it to saying, we just like to tell people it works. Because every time we give a little bit more detail, we want to know more. But how does that work?
Right.
How does the documenting this work? A while back, I designed a locking mechanism for a knife, and we had a family friend that was an attorney, and he said that I should basically write up everything I had done, seal it in an envelope, mail the envelope back to myself. But this was 20 years ago, and so in the modern day with
So this half true, half not. So taking notes is good, and dating it, having a notebook and records of what you've done, and things like that is good and helpful, particularly just in later on being able to establish when things happen.
However, the law has just changed, and I have not read the new law. However, what they've changed is from a first to invent system to a first to file system. So I believe,
Which would mean that doesn't matter anymore.
so we need a legal opinion here, but I believe it makes it much less important to keep logbooks and so on, because what matters is when you file, not when you invent it.
When I looked this up on Wikipedia, it had the example of mailing things to yourself and said that's a total lifestyle. It's not true.
okay, and even I mean, yeah, this was
Yeah, it's a common thing, but it doesn't. They said that doesn't actually mean anything.
But if you
Not
don't-
in U.S. law.
If you don't get much mail, it might cheer you up.
Right. Other patent questions?
So from my understanding, the first filing is you file for a provisional and you have a year to modify your application. But when you actually go to court, people
It's not required to file a provisional either. Provisional is a one way to potentially spend less money up front, more money overall, but establish a date and get something filable, spending less money. It's generally going to delay the process some, but can be a more cost-effective tool for startups.
Just so it doesn't go without saying, a patent is basically a deal. It's a quid pro quo. The government grants you a monopoly on this technology in return for you disclosing it to the world. So when your patent issues, everybody in the world now knows your invention, and therefore can start building off of it and planning to improve it later because you've disclosed it. But the quid pro quo is you get to protect it for 20 years. So some people choose not to patent because they don't want to disclose what it is they've done. So they use one of the other methods of protecting their property.
So that leads us to our next topic, trade secrets. So what is a trade secret? A trade secret is like a patent that you don't want to disclose. So examples of that would be formula to Coca-Cola. There's not a patent on the formula for Coca-Cola, it's a secret. And so the best way to keep the secret is just not to tell anyone. And that's what they try to do. They've done all these things to try to make sure not to tell anyone. Another example of this might be SEO tricks. You might have different things you've developed that you find ways to optimize your website that you think are very novel and innovative and non-obvious, and yet you don't want to patent them because you don't want someone else to know. I mean, an SEO trick won't be good 20 years from now anyway, but it's just an example of something that you would consider a trade secret. And so there's going to be things you develop inside your company that you think are really valuable and important but aren't appropriate to be patented, and you want to be able to protect those. And so a big part of that is just if you don't want to know, don't tell anyone. Restricting the number of people in your company that you tell, making sure that it's marked confidential so that everybody within knows that. I believe you can actually formally market a trade secret. That's not something I know a lot about. That may just give you additional damages, if somebody were to violate it. But nothing you're going to do is, all you can do is minimize your, maximize your what you can sue somebody for or what you can get mad at somebody about. In the end, the point of the trade secret is just you don't want anyone to get the secret because once it's out, it's out. So the main thing you can do is actually just try to develop internal systems to protect it and make sure that as few people see it as possible.
3 people can keep a secret if 2 of them are dead. If you have a trade secret, you shouldn't tell everybody in your company what it is. So some companies are structured to separate the various trade secrets of their operations so that only these people have to know it, only these people. And Coca-Cola ships its syrup around, but it doesn't make the soda. You understand? So it makes its syrup in secret and then ships it, rather than have its bottlers make the syrup.
Another one I should have put up here didn't is Google PageRank. Right? So everybody wants to know what's the algorithm for figuring out which page is most relevant. And it changes over time, but that's a trade secret. It's something that very few people inside of Google know, and that everybody wants to know. And they have to work really hard to protect it really carefully. So those are trade secrets. Do any of you have trade secrets? Yeah, it's like the patent question. You can say what it is without disclosing it.
You can say that you have one, but don't tell us what it is.
Yeah. Nobody?
So would an algorithm qualify as a trade secret?
Would what?
An algorithm would qualify?
If it's not patented, possibly. Yeah.
Is it all code you write in trade secrets?
You don't have one.
I mean, I think if you say all the code we write is a trade secret, you're abusing the term because it's be less valuable to you because I think the intent is all your code is copyrighted, which we'll get to in just a minute. All your code is protected, but a trade secret is really meant to signify the most important things you have that probably that stick out among the others. All right, so let's talk about trademarks. So here's some examples of trademarks. Apple Walmart, other inbox. Just do it. Think different. So names, there could be icons up here, I don't have any, but slogans, logos, the general kind of thing with what a trademark is. My slides apparently are mixed up.
A comment on, you can say more about trademarks.
Yes. You want to make a comment on this?
Ethernet was a trademark.
A trade secret. Trademark. Trademark.
The word, you talk about the word.
It was a registered trademark of the Xerox Corporation. But then when there was an effort to make it a standard, people said, well, we're not going to use that name if it's a trademark of Xerox Corporation, so Xerox let it go. So it is now my trademark. I own it now. I have what's called moral ownership. So what I do is I watch how other people use the word. If I don't like it, I tweet them something like it.
You also have the word networking. At least he told me, and I was using the wrong use of it. Okay, so trademark, usually a name, word, phrase, or logo. It's usually restricted to a particular use case or industry. Apple is actually starting to broaden out. It used to be Apple Computer, and it was applying to computers, but there was Apple Moving and Apple Leasing, and you could have all kinds of other Apple companies as long as they weren't selling computers.
Well, the big one was Apple Music, Apple Records.
Apple Records?
Beatles brand.
Right?
And so the two brands existed in parallel for a long time until what thing happened? Yeah. And then Apple got too close to Apple Records, and I think Apple ended up buying Apple Records.
Yeah. So it gets confusing maybe as the brand changes. For most of you, it won't be that confusing. When you have your brand, other inbox, your company name, your logo, other things like that, you don't have to do anything. You can just put a TM on it and mark it and say, this is mine. You should do that. You only have to, if it shows up many times on a page, you only have to do it the first time it shows up. So you don't have to like TM everything. But the first time it shows up on your web page or other places, you should have a TM on it. If you have your logo on your website, that should have a TM on it. It should be part of your logo. If you have like an image file that you're sending around, there should be a TM on that thing that you're sending around. And that's just good prudence. It's easy to do. And that does protect you. You get more protection when you actually go register the mark with the government. And that lets you put the little R in the circle. So the difference between a TM and an R is the R, somebody went and paid and registered it. They've got a stronger basis for it. It's been approved by someone like a patent examiner. Someone's reviewed it to see that it meets the criteria. It's not too broad. And then you'll be able to register it.
So when I worked for Xerox, we were frequently told that there are two R's in Xerox. There's one in the middle, and then there's a little one at the end.
Because they wanted to make sure that
They
you were
didn't
using
want it to become a generic, so they didn't want people going around saying, make a Xerox copy of that, but use a Kodak copy or an IBM copy or a Japanese copy.
That didn't work, unfortunately.
By degrees it did or it didn't. Kleenex is another one of those brand that became commoditized.
Band-Aid?
Escalator. Escalator was, that's something, they didn't defend their trademark in the lawsuit.
What is the difference between TM and SM?
A trademark and service mark. I don't really actually know what the significant difference is, but generally a service mark is going to be more of a, I think like that service-related business. Sounds right.
I think if you're like printing it on, like, so if like printing on like a Kodak, like tangible, that'd be like a trademark. If you're like Accenture and you're like doing consulting services, then like Accenture's probably service mark, I'm not sure.
It's literally just the differential between a service and a physical product.
And also you can't use famous brands, like I think Coca-Cola and Apple are famous brands. Because they're ubiquitous, so you can make Coca-Cola jeans.
You can or you can't?
You can.
Yes or no?
You can.
You cannot.
No!
You can.
No, you cannot make Coca-Cola jeans. But because they're trademarked.
No, because
No,
well,
there's
it's
a famous
famous
brand. So it
escapes the category.
Right. Makes sense. You can't make Josh Bear jeans either.
Maybe you've heard the ads on the radio from Apple. There's an Apple that's Apple Cars, no problem, there's no confusion between Apple Cars and, they even have an Apple in their logo.
Oh, wow.
But it's not a computer, so no problem. So apparently the logo Apple has a,
I don't think Apple's a famous brand right now. That's definitely.
I guess
They took to a record company. Yeah, they did suit. Still, it was Beatles. Yeah.
That was their thing. It's like, oh, we're Apple Computer, not Apple Wear.
no, but when Apple got into the music business.
Right,
Yeah.
and it became a.
So how many of you have TMs on your logos?
I'm putting one on there now.
How many go tomorrow?
So that's easy, you should go do that, you should put it on your websites, on your logos. And so I assume nobody's registered a trademark. You probably don't need to do that. We didn't do that till 2 or 3 years into other box.
So is your company name a trademark?
Should be.
I don't actually know the answer to that.
Well, Wikipedia says it's usually a name, word, phrase, or logo.
So, one point about that
Yes.
is, the TM next to your name doesn't really do very much for you in terms of protection. Not nearly as much as the registered trademark is. Whenever you bring something into like form, like once you like put on a piece of paper kind of thing, that's technically trademarked. It's like a 1970s ruling, copyright protection.
Right, it's copyrighted, not trademark.
Yeah, but
It's a
like
different thing.
but the trademark thing is like anyone can write TM next to something.
Right.
It doesn't really provide you any legal protection.
Well, it says you're claiming it.
Yeah.
And I believe it does provide you some protection. It's much stronger if it's registered.
Well, yeah, but very minimal.
Anyway, just to make sure we get the point of this though, are you saying they shouldn't do it?
What's that?
But you're
I'm
not.
saying it doesn't matter. But you should do it. I mean,
Yeah, I
because
think,
there's nothing hurting you by not
yeah, I
doing
mean,
it. There's nothing preventing you from doing it.
Yeah, you should do it. Like, you
Yeah.
should put it there. It's definitely better to have it than not to have it.
There's nothing.
Yeah.
So I know there was pushback saying that you can't really follow your own patent legally.
You guys, one at a time.
So there was pushback on filing your own patent because of the legal nature and the language, but is that different on trademarks? Are your trademarks fileable by you? And if they are, like, you said you estimate like $1,000, but I know that you use like a little bit less than that, like 300 or something like that.
You might be able to find it to get done cheaper too, but, you know, in general, I'd say if you think it's important enough to take the time to do this, you should have a lawyer do it.
Okay. We're talking about original patent.
We mentioned it briefly.
Oh, okay.
Yeah.
Do you know how long trademarks last?
I don't. Probably forever.
Okay.
Anyone wants to Wikipedia it right now? They can find it.
As long as you can defend it. That's
I
the
thought
rule.
that's
So as long as you can defend it, if people start using it as like a generic term and you don't go and defend it, you will lose it. That's use it or lose it.
But Disney's been a brand for a very long time.
But they'll sue people. That's what you do.
Yeah, but there's no 20-year limitation as
It's
on patents.
infinite as long as you keep.
It's really, yeah, it's a renewable thing.
Now, separately from that, though, not getting into copyright, there's, you know, Disney is actually often held up as the copyright kind of demon of, at least if you listen to Larry Lessig and Creative Commons and things like that, because somehow the copyright is only supposed to last for a certain amount of time, like 50 years or something like that, but every time it's about to expire, they keep working out a way to get it extended, so that like Mickey Mouse like should be in the public domain and just isn't, and just like keeps getting stuck further and further. So copyright is an interesting one. It was really originally produced to give people the right to make copies. I think it was actually for Bibles originally in England. But really it's about stopping people from exact copying of things. And if you're doing software stuff, this is actually one of the stronger things you have and more useful things you have. It's hard to debate whether somebody copied your algorithm or things like that. It's easy to see whether or not they just copied your code verbatim or your website. And so this is something you can actually enforce and hold, and you have copyright. It's good for software code, it's good for your website and your marketing materials. You do not have to put a C on them. They are copyright by default. It's a good idea to still do it. It's going to help maximize, kind of like in a more strong, less strong case than the TM and the registered trademark. It's going to give you more damages, more ability to pursue it. But that's basically copyright. And so, examples here, you want to have the C at the bottom of your website saying, copyright year, your date. in your code, in like your header files, where you have comments in your code, you should be putting at the top of your code, this code's copyright, it shouldn't be copied, it shouldn't be used. So there's some basic things that you can do to protect that data. But basically everything that you're creating is copyright. Questions on copyright?
Oh, it's something you apply for, just, is just immediately?
You do not have to apply for it, there's no registering it. You can put the, you mark it and,
Just defend it?
defend it. So, we have one or two more things to talk about around governance, which is a related topic, but that's most what we have on intellectual property. So that's, I would consider that a light introduction. That was about 45 minutes. That was clearly the we're not lawyers perspective. Like I said, there's a lot more information about this. We can get you more information about this if there are specific areas you have questions about. But hopefully that was a helpful introduction. Any other questions about intellectual property stuff?
I was gonna ask you, what's a good way to, like, if you're talking to investors, to kind of sell your intellectual property, with your pitch?
I mean, honestly, in general, I wouldn't be selling your intellectual property.
Well,
But
I know that's what I mean, I don't wanna come out.
I'd be putting it in terms of those things we talked about. The practical things are, this is going to be defensible. Having this patent is going to give us freedom to operate. We're not worried about other companies coming and stopping us. And this is going to be valuable. Later on, as this thing starts to really scale, other companies are going to see this as valuable, that that we have this property. Anything to add, Bob?
So how do professors, who don't have large companies defend their patents?
They do have a large company.
Oh, well, some.
The university.
Huh? Oh, okay, the university helps defend it, oh, okay.
I mean, Bob probably can speak more to this than I can, but.
So when professors invent things, they file invention disclosures that go up to the Office of Technology Commercialization. And because the professors are paid by the U.S. government and the university to do their research, there's a claim of ownership on what they produce. Most of it is not useful, novel stuff. So the Office of Technology Commercialization has to decide whether it wants to patent things. So huge disputes arise between the university and the professor. The professor thinks he's invented the wheel, and the office says, yes, you have. It's already been invented. So there's a big, but then the university, in many cases, decides to file a patent, and then license, and then tries to license it. And they can license it back to the professor's company. If the professor starts a company, the university may also license it to a huge company somewhere else that wants to pay more for the license.
So the university retains, majority of the ownership of the patent, or absolute ownership?
Absolute ownership. Now, at various universities, there's a deal as to how any royalties are split. So at MIT, for example, it's a third, a third, a third. The professor gets a third, his department gets a third, and the university gets a third. In Texas, it's more generous to the professor. It's 50-50. The professor gets half of any royalties, the university gets half. Usually when the patent is licensed by the university, the obligation to defend it goes to the licensee. The university doesn't want to have to defend your patent. So your question was a very good one. There is a big company, but it doesn't want to defend your patents.
All right, so last topic for tonight is incorporation governance. So I'm going to turn over to Bob.
Yeah, I'd like to just say a few words about this and see if there are any questions. Once again, this is largely a legal matter. So ultimately you will incorporate or not with a lawyer help. But what you are doing by starting companies, you're creating a new entity. And a technology was developed called incorporation. So this is more machinery of free enterprise. So you create this entity and it has several forms which we won't get into, a C Corp, an S Corp, an LLC, those are all variations of corporation. But the purpose there is to create an immortal trying to build a healthy, scalable company, you will have all your IP owned by the company, not by any individuals in the company. An investor, for example, will shy away from a company where the inventor has reserved ownership for herself instead of giving it to the company. So the company, as a general matter, should be the entity that owns everything, like the trademarks, like the copyrights, like the trade secrets, and so on. Now, this entity is owned by its shareholders, and then the shareholders elect the board of directors, and then the board of directors appoints a chief executive officer. The chief executive officer is responsible for running the company, building and setting strategy, and very few things are approved by the board, other than appointing the chief executive officer. There are some other things. Usually boards routinely approve annual operating plans to authorize the expenditure of funds. Boards also approve the granting of stock options to employees. That is a very short summary of governance. But I wanted to make the point that the intellectual property that we've been discussing generally is owned by this entity. So when a license comes from the university, the license will be taken by the corporation. So in the case of a professor at a university who invents something, he or she could have two sources of income from that patent. One is through the royalties that go through the university, which they may have in Texas. But if that professor owns stock and receives salary from his company to which that patent was licensed, he's very likely he will receive more compensation from the company than goes through the university. Did you follow all that?
No, I didn't.
I'm not sure I followed it either. Professors really get all upset about the royalties from their patents, how much they get. Half is the answer. But in practice, they often get more compensation if they start a company, license their own patent from the university. They'll make more money on the company than they'll get from the royalties that go through the university. I think I just said the same thing twice. I tell you what, no, I'll raise my voice this time. That's really, I think I should stop there unless you all have questions.
Okay, great.
Assuming, how many of you have boards of directors for your company? How many members? How many employees? How many shareholders? Yeah, my company, for the first 6 months, I was the shareholder and the director, the whole board, and the chief executive. You know, if you like having your own way, that's the way to do it.
Were you also the only employee at the time?
Yeah.
Oh, okay. Who worked with you?
That's a very serious question, but I found some eventually.
All right, so a couple things to wrap up. So one, just want to reiterate on culture. So that's going to be the topic for next week. Brett Hurt's coming. Brett's a great speaker. He's a great entrepreneur. He's personally one of my mentors. When in all, no bullshit. When I'm like really stuck about something, I'm trying to figure out what to do. I'm like, who's Brett to? And I call Brett. He's one of a small number of people that I think of that way. And so really look forward to having him here. He's built an amazing business through Bizarre Voice and an amazing culture there. And it really, and for them, becomes a competitive advantage. Get ready for that. I would spend some time thinking about your mission statement, your values. It's not like he's going to spend the whole time talking about mission statement and values, but that's an easy place for you to start thinking about your company. And then assignments for next week. So again, watch John Price's talk on selling. The link's also on Facebook. And think about your company mission statement and values. Anything else you want to say before we wrap up?